So the first speaker that we're going to hear from is Dr. Ciara Bracken-Roche, who's an assistant professor of criminology in the Department of Law in Maynooth University, and she's also a visiting professor at the Department of Criminology in Ottawa this year. Hopefully she's going to actually get there at some point. She sits on the International FOI Research Council of the Centre for Access to Information and Justice at the University of Winnipeg, and she's also a long-standing member of the Surveillance Studies Network. She's looking at a project currently around the adoption and use of drone technologies in both Canada and Ireland, with a specific focus on their application by policing and public safety agencies. So I think this is going to be absolutely fascinating. So yeah, I'll hand you over to Ciara.
Great, thanks a million. Thank you for the introduction, Vicky, and thank you, Annalika, for inviting me to take part. Hopefully you can all hear me all right, and my office isn't too echoey. Great, thanks, Catherine. I won't introduce myself then because Vicky has already done so. But for the talk today, I'm going to focus on issues related to surveillance, including but not limited to the use of drones in response to the COVID-19 pandemic. For my talk today, I'm not going to use slides. I will try and keep it structured so it's easy for you to follow. I'm going to briefly discuss some of the surveillance measures and technologies that we've seen introduced globally and in Ireland, more specifically in response to the pandemic. And then I'm going to give an overview of kind of 5 key surveillance considerations that I think we need to engage with when looking at the adoption of new technologies in response to a crisis and how these might impact individual rights and freedoms. So we know that surveillance and public health monitoring are key in responding to the pandemic. They are intrinsic to the work of epidemiologists and always have been, health professionals and public health agencies. But these practices are subject to kind of strict legal limitations, which are intended to limit undue harms to the population at large. Technologies, however, are not neutral, and as such, civil liberties, privacy concerns need to play a central role in the conversation when they're introduced to society, even in the times of a crisis. The same can be said for the introduction of emergency measures by policing agencies and public safety agencies, so like the Gardaí in Ireland. And those measures as well need to be limited in scale and scope and subject to discussion. As many academics and activists have argued, we can't police our way out of the pandemic. That's not the way this ends. That's not very helpful. And nor should we expect individuals to be subject to unnecessary levels of surveillance. So with that in mind, let's think a little bit further afield. So smartphone contact tracing apps have played a huge part in the response to the COVID-19 pandemic internationally, but they're just the tip of the iceberg in terms of surveillance technologies being introduced in response to the pandemic. So in several countries, and I'm sure you've all seen this in various ways in the news over the summer, drones have been used to monitor things like social distancing, as well as to monitor people out and about and tell them to wear their masks. CCTV has been deployed alongside thermal imaging used to read people's temperatures in both kind of public spaces as well as in semi-private spaces. While approaches kind of differ in the way that these technologies are deployed from country to country, there is a trend and a convergence around the broad use of all of these emerging technologies to tackle this health emergency. And so the extensive use and multiple applications of drones in the current pandemic have raised several challenges that I want to highlight here throughout the talk. So I want to look at technological accelerationism and solutionism, function creep, the importance of various kind of societal concerns and the appropriate use of privacy and data protection measures, as well as security and safety issues more broadly, and the potential abuse of this state of emergency. So often what we see happening in a time of exceptionalism is the measures that are introduced become normalized. And then they extend to other objectives at the same time or after the crisis has ended. So we'll get into that a little bit. I think my talk will hopefully work nicely to premise the other ones in a more perhaps philosophical bent, to have everyone thinking about surveillance in its own way as it relates to the technologies that have been introduced. In Ireland right now, An Garda Síochána do not have their own drones in operation, but there is a working group that is considering the adoption and the possible applications for these technologies by the Gardaí. But many county councils have drones, and they were taken up under the anti-dumping initiative. So this leads me to our kind of first example about drones in Ireland for use in kind of the pandemic state. So earlier this year in April, there was news of the Wexford County Council using their drones to monitor public movements in caravan parks and holiday homes. Primarily to make sure that people were adhering to that 2-kilometer travel limit that was imposed during the kind of March-April lockdowns. Recently, in response to a complaint received about these operations, the Irish Data Protection Commission ruled that the council failed to adhere to the law by using drones in this way. And so this is significant because while AGS don't have drones in operation at the moment, many local authorities and county councils in Ireland do. And whether it's they have them themselves or they hire contractors to operate drones on their behalf, they're using them regularly. So the Data Protection Commission's ruling to say that this use was inappropriate is noteworthy. And it kind of reminds operators who are using drones that they are subject to Irish data protection law, as well as the GDPR. A key thing in the Wexford case was that there were no data protection impact assessments conducted before the drones were used. So a DPIA is usually where you kind of outline any privacy implications that your project might have in terms of the data that you're collecting, that you're processing, and so forth. And so this would be a prerequisite for any project before you carry it out in order to uphold proper protocol under the GDPR. And so this had not been carried out in the Wexford case, and thus a complaint was lodged to the Data Protection Commission. So the Data Protection Commission investigated. They saw that there was about 13 hours of drone footage. It captured kind of observations of beaches and caravan parks, holiday home estates, but none of the images contained anything identifiable about people or the vehicles that were being filmed. So because the images captured were kind of from a far distance and of low image quality, they didn't contain any personally identifiable information. And so the Data Protection Committee kind of said that no data processing took place. They also said that they believe that this use of drones in this particular case fell under the law enforcement provisions of the Data Protection Act in 2018, which is an exception kind of to the rule. And that because no personally identifiable information was collected, they, they kind of were getting away without a fine. There was no punishment, but they still should have conducted kind of a data protection impact assessment. So they got a slap on the wrist. But I think this was a significant move to see how drones might be used to monitor the public. The fact that we don't really have protocols in terms of, reacting to their use as well. The technologies are so new. Not that we need to be technologically deterministic in how we address them. It is something that we see this kind of struggle for the law and the tech to kind of match up and interlink. So With this case in mind, I kind of want us all to think about what it means when we're adopting drones or other surveillance technologies more broadly in the context of a pandemic. So the first thing is that the need for rapid response and new ways of coping with the pandemic has led to this kind of technological acceleration and solutionism. So the fast growing use of drones in response to the current pandemic is an illustration of how exceptional events can act as a technological development and employment accelerator. Technological development refers to the speeding up of various research and development processes that lead to new technologies, while the employment of existing technologies is kind of multi-layered and manifested in different ways. Technological solutionism kind of refers to the way that technology is offered as a solution to all of our problems in a frictionless way. So with drones, this meant that many of them were repurposed to perform new tasks, as we saw in the Wexford case. It also means that new pilots can be recruited or trained to kind of operate the technologies, and that tasks can be ascribed to drones that were already possessed by different technologies or actors. In crisis scenarios, especially in a declared kind of state of emergency, the alleviation of regulatory requirements may also occur. So we saw this with the emergency measures being introduced for the Gardaí, and we see this around kind of regulations that look at the technology themselves as well. We didn't see this in Ireland, but in the case of drones, in various countries, rules for the circulation of them within civilian airspace were shifted. In Italy, for example, their Civil Aviation Authority approved a time-limited authorization for police to use drones to monitor the movements of citizens during the pandemic. And so the acceleration of processes related to the technology's development and employment might lead to new or extensive uses of particular technologies, which kind of pushes the bounds of public acceptance. So are we willing to accept these technologies because of the exceptional state or not? So there's that constant kind of flux there. Another thing I wanted to introduce was the idea of function creep. So this is quite familiar. There are many names for it. Mission creep is another one. And I think this is a phenomenon that we need to be particularly aware of in relation to technologies being taken up in particular ways and introduced during the pandemic. So this really is the process whereby a technology or practice is introduced for one express purpose, and then it's taken up and used for other purposes. So it shifts in terms of what its original mandate said it would do into what it now does. And that usually occurs once public acceptance has happened to a degree. So once a technology has been normalized for one purpose, it's often appropriated for other purposes, uses, or missions. What's distinctive about it is that when it shifts from one application to the next, there's not really a conversation about it. So even though the impact might be different, because of that kind of subtle creep to another area, it kind of removes space for dialogue. So then we can ask, do some of the current drone usages internationally during the pandemic exhibit function creep, or even in the Wexford case? Or are we just seeing an example of kind of function expansion? And I think this issue is open for debate. Answering the question really will require us to look at the kind of long-term uptake of the technologies in this kind of prolonged pandemic situation, amongst other scenarios as well. Some of the most intriguing applications that we've seen in terms of the layered aspect of drones during the pandemic is the way that they've been coupled with different thermal and sensorial technologies to allow the monitoring of the temperatures of the population. So in some places, drones have been equipped with sensors that allow them to monitor people's temperatures as they move about and monitor individuals in public space. So therefore, drones are being used as multitask platforms beyond their initial remits, where different technologies can be employed to combine different sensorial tasks, which in turn further challenges the relationships that we see emerging. In terms of privacy and data protection, over the last year, we've seen that no matter what the purpose, whether it's recreational, commercial, humanitarian, drones raise real privacy and data protection issues. Concerns aren't just in terms of contemporary real-time surveillance, but also, and perhaps more importantly, it's regarding the amount of data that drones can generate, and that needs then to be managed and controlled according to specific legal requirements. Some of the countries and regions that are using drones as part of their pandemic response have the world's strictest data protection regulations. So we've seen their use in Europe, and they would be subject to the GDPR. And in California, you've got the Consumer Privacy Act, and drones have been used there. But it's almost certain that these regulations will be infringed during the pandemic because it is under a state of emergency that the technology is operating. And so here, it's important to think about what they're doing. They're gathering video and imagery data, private temperature, and possibly other biometric databases, as well as, geolocation data. And all of this can be kind of cross-examined as metadata about individuals and about the population. So this opens a series of kind of ethical and legal issues that needs to be addressed before the technologies are introduced. There's some concerns as well regarding accidents with drone use and criminal activity. The increasing proliferation of drones within civilian airspace more broadly will increase the likelihood of accidents and may also kind of facilitate criminal activities. Accidents might happen due to the failure of technologies with collisions in airspace or by the breakdown in the delivery of cargo, perhaps. And criminal activity can happen through many forms, in particular by hacking drones that might be being used by law enforcement or humanitarian actors, by using drones to deliver contraband amidst a drone-populated airspace. So if you're not able to tell who's operating which drone, and by using drones to conduct some sort of attack. These have all come up kind of over the years, but if we start seeing increased proliferation of drones kind of within the sky, it becomes more difficult to distinguish one from the other. The situation then becomes further complicated by the fact that any counter drone technologies that might be able to kind of trap them or take them down or stop them operating aren't always fully effective and raise issues around kind of planning and safety. And so as drones kind of continue to operate in airspace, these challenges will keep growing. And then my last point is on the normalization of exceptionalism. So all over the world, states are responding to the challenges of COVID-19 by invoking a state of emergency. And so generally, this is characterized by the expansion of state power, allowing it to perform actions and adopt exceptional measures that it wouldn't normally do in a time of normal politics. And so the state of emergency allows for the adoption of extraordinary political, financial, and administrative resources, as well as authorizing new security practices, like we've seen with various technologies. And so the widespread use of this state of emergency creates the conditions that could lead to the normalization of exceptionalism once the emergency is over. So once everyone becomes used to this state and the technologies, it could carry on and be a mediator in our life in days to come. How am I doing for time? Do I have another couple of minutes?
No.
No, I'm up.
No,
okay.
you're at your time minutes, yeah.
Okay. Let me just wrap it up then. I mean, I think philosophically, there's numerous more questions that we need to ask. How will the public react to the technologies? Would there be more of an acceptance that will continue after these exceptional times, or will it be understood as being increasingly invasive? In most countries, people are willing to cooperate with public health measures and a level of policing and surveillance that are reasonable. This protects individuals and ensures a state's kind of political legitimacy. And so in Ireland, I think we need to stay the course and not adopt kind of these exceptional technologies. And we need to ensure that that conversation around civil liberties, human rights, and privacy are at the center of every debate, because those are still key in effectively fighting the pandemic. Thank you, and apologies for going over.
That was absolutely fascinating. I think it's really, and it's merging different themes. I'm sure Mark is going to touch on this, but we're no strangers in this country to emergency situations leading to exceptional measures that become the absolute norm. So I think it's really important that we're thinking about the breadth of that and balancing, you know, the public health considerations and needs in all of the measures that you're talking about against the very real potential impacts for human rights and privacy considerations and so on. And we'll have questions at the end. I think this could work very well in terms of cohesion between the papers. So we're next going to hear from Dr. Mark Coen, who's going to talk about trial by jury during a pandemic. Mark is one of Ireland's leading experts on jury trials. He works at the Sutherland School of Law in UCD, but he's also previously taught at Trinity, DCU, Durham, and DIT, which is now TUD. And his PhD was on appellate judiciaries in Ireland, England, and Wales, and allegations of judicial irregularities. He's recently been doing a really interesting study with some of his colleagues, Neil Powlin and others, on judge-jury interactions in Ireland. And it's a really original, unique empirical study examining the relationship between judges and juries in Irish criminal trials. And it's really exciting to have such kind of empirical work being done in Ireland. So it's going to be great to hear from Mark for 20 minutes on jury trials during COVID. Thanks so much, Mark.
Thanks very much, Vicky. Can people hear me? Just a nod or two would be good. Thanks. Yeah, sorry, my audio dropped out when Ciara was speaking at the start. So yeah, I usually introduce an element of technological glitches to anything I get involved in. So you've been warned, Anne-Marie. Thanks very much, Vicky, for that very kind introduction. And it's great to be back virtually at DCU. And thank you to the Dublin Law and Politics Review for the invitation to participate in this event. So I usually find myself talking about trial by jury, but I suppose we're all talking about the pandemic and have been talking about the pandemic for a number of months now. It's our main topic of conversation, and I suppose one of the more hackneyed things that we tend to do in everyday life is to just sort of reflect on the great changes it's brought about in our lives. And that's true, I think, for every aspect of life, including the criminal justice system. And certainly aspects of trial by jury that I thought were academically interesting, but would never, really be questioned in real terms, have suddenly become quite topical. I think, as Vicky said, as time goes on, I think things will perhaps be considered that we would just never have thought would be necessary or imagined that they would arise. So I'm talking about things like, well, do we have to have jury trial for non-minor offences? Okay, the Constitution says we do, but is there any wiggle room that we can get out of it in those situations because of the pandemic? Can we reduce jury size to make juries smaller for practical, pragmatic reasons, to make social distancing easier? So these kind of questions like, what's the constitutional position on the size of a jury? I mean, as I say, they were things that I'd thought about and read the relevant cases and talked about in my PhD, but you never really expect anyone else to be very interested in them, to be perfectly honest. But suddenly they have a currency, and that's kind of good, but also kind of a bit scary, I think, because they're sort of certainties that we all just expected would never be questioned, and suddenly they're up for debate, or you feel we're moving through different phases of living with COVID, that dreadful phrase. And, you know, as we go through different phases and time passes, I think our, you know, political engagement with what the appropriate measures should be. I mean, it's already shifted really from where we were in March. Maybe it will shift back, but I think sort of the menu is changing all the time in terms of what's thought to be acceptable from a public policy point of view, and you know, what might have to be. You know, we can debate whether it has to be or not, but what might have to be considered to make certain things workable or possible. And I think it, yeah, challenges us in so many ways, as Vicky said. You know, the question of resources is always there in the background. Questions of public policy, of choices in relation to due process and rights. So yeah, I mean, I think this time last year we didn't know what was going to, you know, we were living in blissful ignorance this time last year. You know, we'd no idea that so much would be up for grabs, you know, a year later. So in terms of trial by jury, I suppose it's always important, I think, to say at the outset that, you know, trial by jury is the exception in our criminal justice system. It only happens in a tiny subset of criminal trials. Most criminal matters are disposed of summarily in the district court, but, and it's a big but, you know, lay jurors decide guilt and innocence, guilt or innocence, in the most serious criminal offences in our on our statute book. So you know, it is a tiny percentage of trials, but they are the most important trials in terms of having the most significant, well, every criminal trial is important, but the consequences of the trials that jurors determine are the most serious consequences. They are the most serious offences. But I think I always feel it's just important to acknowledge that from a numerical point of view, you know, jury trial is the exception rather than the rule. I also like it's you know, very cliched, but if you're talking about trial by jury, you have to sort of refer to Lord Devlin's Hamlin lectures, and I like to quote the opening line of his Hamlin lectures, which isn't really ever quoted by anyone. You know, everyone sort of quotes where he says, "The jury is the lamp that shows that freedom lives." But I think his opening line is hilarious. He says, "Trial by jury is not a subject on which it is possible to say anything very novel or very profound." And I think even, you know, I just think that's hilarious that someone who's setting out to give some lectures and produce a small book on a topic would start in that way. But I think even Lord Devlin would have to, if he were with us today, would have to concede that COVID-19 gives us plenty to say that is novel and you know, hopefully interesting. So I think if we wind back the clock and go back to March in terms of what happened, basically, as we all know, we went into a very strict lockdown. No new jury trials started at that time, but I think it's interesting that the jury trials that were ongoing at that time continued and continued until they were finished. And I think that says something really interesting about the sort of criminal justice system's attitude to jury trials. Once it starts, it has to finish unless it becomes derailed. One would think maybe that a pandemic that was locking down the country and restricting all of our movements might be such an event that would, you know, stop jury trials from happening, but no, they continued on. And I was very struck at that time in March by an Irish Times headline which said, "Jury urged to stick with trial despite coronavirus." And I don't know about you, but certainly when we went into lockdown first, I was totally petrified. I mean, I didn't, you know, and I was listening to the news way too much. I was hearing things like 70% of us are going to get this, you know, like this is really serious. And I remember just seeing this headline, you know, jury urged to stick with trial despite coronavirus. And yeah, I found it kind of odd. I suppose I felt the whole thing should have been, you know, unfortunately, you know, we're in unforeseen circumstances. Jury trials, no matter how long they've been going on for, we'll just have to stop them and come back to them, restart them at another stage. I know that in itself would have been a drastic measure, but because that trial, for example, was a trial that had, I think, already lasted for 5 weeks. So a huge, you know, number of witnesses would have given evidence. Obviously, that's a lot of court time, involves huge resources. But at the same time, I did feel for those jurors who were being told, you know, stick with this for another week, even though, you know, everyone is terrified of this pandemic. So the trial judge, Judge El Mashihan, said, according to the news report, things are not easy for anybody, but these are most important matters, and you've given them your full attention for the last 5 weeks. I'd ask you to stick with us for the next week in terms of dealing with the matters. And apparently she told them, you know, the court won't be as crowded now because everyone else is locked down. The building will be quieter. There'll be more space for your lunch and so on. But yeah, I just thought that stuck with me, that the trials continued. And at the end of March, there were still 4 jury trials in the criminal courts of justice that were taking place. One of them ended up being a very long-running trial, the Aaron Brady trial. So while the courts were shut down, obviously we have this growing backlog of cases caused by the fact that jury trials were not happening. Obviously that has an impact on victims, it has an impact on accused persons, witnesses. And then I suppose we got to the summer and the idea that, well, the numbers were down in terms of the virus, you know, jury trials would be able to resume in some fashion. And I suppose this, when I thought about this issue, so I wrote a blog about it during the summer, and really what struck me was that really there are 2, I think, distinct approaches to reacting to COVID-19 in terms of how it affects jury trials. One is the very practical approach, you know, what can we actually physically do to make the process of a jury trial sort of fit into the new normal of social distancing, lack of congregating, and so on. And then the other, so that's kind of one path on the road, the kind of practical steps. And the other one then is legal and procedural change. You know, do things have to change, you know, in terms of the essence of what happens in a jury trial? Or if not the essence, because I suppose you could say the essence of a jury trial is, you know, lay people deciding on guilt or innocence. If not the essence, then features that we would certainly have regarded as, you know, important elements of jury trial, or would have taken for granted, the fact that there are 12 jurors, for example. So when a small number of jury trials started in July, I mean, you know, the court service had a bit of time to think about the practicalities. So, I mean, it's a huge operation. Even things like, you know, that in a jury summons now, you know, like health and safety information is included, you know, all the things we're familiar with, you know, the cough etiquette and so on from everyday life. But, you know, it's another administrative thing that has to be considered. The empanelment process then, so generally, you know, hundreds of jurors are brought in to empanel a number of juries for in the criminal courts of justice, or similarly around the country. You need 12 jurors, but you need to call vastly more numbers of potential jurors. You know, so for a trial, for one trial, you might call 100 or 150. You know, or sorry, you might call way more than that actually, because there's a huge rate of people who don't respond to the summons. But the court service would be hoping that maybe 100 would turn up, for, and that they would get a jury out of that for 1 or 2 trials. Each side can make peremptory challenges to the composition of the jury. So people are going to fall away because they're going to be objected to by counsel for each side, who don't have to give a reason to exercise those challenges. But sorry, that's a long-winded way of saying this empanelment process generally involves a lot of congregating, people sitting around waiting for their number to be called, to go up to the court to see if they'll be challenged or asked to stand aside, or if they will be put on the jury and take the oath. But there's a lot of hanging around, basically. So, you know, the courts service had to think about, well, we need to kind of look at other facilities, particularly in kind of the county towns where the Circuit Central Criminal Court would sit. You might only have 1 or 2 courtrooms. You don't have the big building you have at the CCJ in Dublin. So, you know, things like hiring leisure centres, theatres, hotels down the country had to be embarked upon. And I suppose the fact that the small number of trials that had started prior to lockdown continued to completion allowed the court service then as well to see, you know, what kind of issues would be, you know, it sort of enabled them to have a small group that of trials that they could learn from in a way. So one thing that I thought was interesting in the Aaron Brady trial was that the sort of you know, the jury couldn't be sent to their jury room because a jury room is tiny. It's like a dining room in a private house, you know, a table with 12 chairs. Okay, maybe a large dining room in a private house, but compared to, I see Vicky laughing there. I do not have a dining room, for the record, but I would like one, but I don't have one. But I mean, yeah, so having been in the jury rooms in the CCJ, for example, I mean, compared to the courtroom, they're tiny rooms. The table fits, the chairs fit, you know, it's like a boardroom, I suppose, quite a tight boardroom. But obviously that's not fit for purpose in a time of social distancing. So in the Aaron Brady trial, and I suppose we might tend to think of a deliberation or a jury room as, you know, that's where the jury go to deliberate, and that's correct. But the jury could end up spending quite a lot of time in that jury room during the trial as well, during legal argument, when they're sent out, and while issues are resolved in their absence. So, you know, it's not just a room they go to at the end. So apparently in the Aaron Brady trial, I was told this by one of the counsel in the case, that the jury were divided, I think, between 3 jury rooms, which I thought was pretty curious arrangement, I have to say, because, you know, it's a fairly fundamental principle, really, that a jury should not be separate. It should stay together. Now, obviously, you can see the practical reason why they were broken into 3 different groups, but I don't know. I think if you were looking for a ground of appeal there, you might be tempted to say, well, you know, we don't know if the 3 different groups became factionalized. Were they discussing the evidence in their 3 separate groups instead of when everyone was together? Those kinds of issues arise. In relation then to the exercise of the peremptory challenge, I don't have a sense of how this played out in general, but I did find a newspaper report which said that in one court in the last couple of months, jurors were told to remove their face masks. Potential jurors, I should say, were asked to remove their face masks so that counsel could have a look at them, basically, to decide if they would object to them. So you can really see, I mean, there's sort of a clumsiness to that, I think, and, you know, there's all kinds of issues floating around there, I suppose, about, well, what is a peremptory challenge? Well, it's a challenge without cause, exercised on the basis of appearance. I don't agree with peremptory challenges at all, by the way, but we can talk about that. Or I think there might be an argument for a very small number, but that you would have that each accused has 7 and the prosecution have 7 as well. I think is kind of overkill, but we can talk about that separately.
5 minutes, Mark.
Thanks, Vicky. But, you know, so there's a real sense of you know, kind of ingrained conventions and ways of thinking, I suppose, being challenged by the pandemic as well. That, you know, this issue arises, well, can the right to peremptory challenge of a juror be exercised if you can't see the person's mouth, I suppose, or kind of half their face? On the other hand, there's very strong public health advice that everyone is supposed to be wearing a mask because there's a lethal virus in circulation. So 2 things in conflict there. And sort of the legal system having to make it up on the hop, really. I'd be interested in finding out, you know, to what degree that was replicated, if at all, in other courts, but I only have the newspaper account to go on at the moment. So, I mean, basically, there are a myriad of practical issues. You know, jury boxes are confined spaces, they're not socially distanced. So, you know, basically jurors now have to sit in the body of the court. Another juror, if there is another courtroom, that's where they have to go to deliberate, which means that other courtroom then can't be used for a trial. So the backlogs are building up all the time. You know, what if a juror tests positive for COVID or is a confirmed case, a confirmed contact of a positive case? A jury in Waterford had to be, I think they had just been impaneled, and it was discovered that somebody had a family on the jury, had a family member who was being tested for COVID. So that panel was just told they could go, and a new jury was impaneled. But there are a host of issues. I mean, the law provides that you can have a juror, you can have, you know, a number of jurors who fall off, up to 3, because of illness, or, you know, for whatever reason, a close relative dies or something like that. But again, that's, you know, if you find out that someone on the jury is a close COVID contact or has COVID, that's not really an option. The whole trial will have to be aborted, because, you know, everyone should be isolating basically who was in contact with that juror. So kind of a host of practical issues. I mean, you may have seen in the newspapers as well that Croke Park, the conference centre there, is apparently going to be pressed into use for an assault trial in January, because there are 8 accused persons. And when you start factoring in their legal teams, jurors, court staff and everything, you know, you're going to have quite a lot of people in a room at one time, and you just wouldn't be able to be socially distanced in a courtroom. So there are some of the practical issues. I mean, I think the stress on jurors is another issue, which is a bigger issue that I think really deserves greater focus generally. Like, we ask lay people to come in, listen to or watch quite graphic things in a lot of cases, and then sort of send them on their way. And the provision of counselling is very ad hoc and dependent on the trial judge sort of making a special case that they get counselling. So that's kind of juror stress in general. But in this context of COVID, we are, you know, we're dragooning these people in to do their civic duty. It's mandatory jury service, but we are also then subjecting them to this risk of COVID-19. I mean, I suppose you could say, well, people who work in shops and teachers and so on are, you know, are undergoing the same risks, but it's sort of another practical issue. In terms that, conscious that I'm running out of time and that the timekeeper is very strict, obviously the other path I mentioned then is the legal path. So in the blog, which Anne-Marie has posted up a link to in the chat, you know, I talked about things like, well, you know, can jury trial be waived? I think you know, I think under the Constitution, no is the answer. The courts have made, you'll see a lot of references to jury trial as a right, which you might think, oh, well, a right can be waived, but the courts have also said, and I think it's clear from the language in which the jury trial guarantee is stated, that it is an obligation and an imperative, that it's mandatory that there will be a jury trial in certain circumstances. I also in the blog look at other things like, well, you know, could you reduce the number of jurors and so on. Happy to talk further about those kind of issues in Q&A. But one thing that kind of struck me when I was thinking about this event was that there are also, I suppose, kind of less radical things that have been neglected in kind of classic Irish criminal justice style over the years that could have actually been very beneficial if they'd been adopted. You know, there's been a long-running conversation for about a decade, if not more, that the whole impaneling process of having hundreds of people turning up is just Victorian, and can that not all be done through, you know, basically some Zoom-like equivalent, people getting text message notifications? Why does everyone have to turn up in person and waste their day? So that's one issue. If that had been sorted out, we'd be better equipped for the pandemic in relation to jury service. And the other one then is preliminary hearings. So for about 20 years, there have been calls that a jury should not have to be impaneled before legal issues are determined. So the admissibility of evidence that people know in advance of the trial is going to be contested, like a confession. You know, so participants in our study, which Vicky mentioned when introducing me, the judges in that study were saying, you know, they often have to impanel a jury and then send them away for days without hearing any evidence while some issue is determined in their absence, and that you're wasting the jurors' time. So again, if that had been implemented, you know, it would make for shorter trials, less complications, and the Bar Council in their COVID document, they've sort of used their COVID document to say, we still think preliminary hearings are a great thing and that they should happen. So I'm going to leave it there, running out of time, yeah, I thought 20, as usual, I thought 20 minutes sounded like a lot of time. When am I going to learn? Thanks, Vicky.
Thank you so much, Mark. Oh, I think it's absolutely brilliant to hear about all of those different practical considerations. But I'm also really interested in the juxtaposition of the two talks already. One where it's like, now be wary of technology, and you're listening to Mark's and you're like, why aren't we using technology more? So I think that's really great. And I'm sure we can tease that out in the discussion. And actually, I think the next paper is really going to guide us into that quite a bit. So we're going to be hearing from Catherine Friend, who's a doctoral student in Waterford Institute of Technology with a psychology background. So she's a degree in applied psychology and a master's in cyber psychology. She's doing her doctoral work on cyber psychology and the regulation of cybersecurity in Ireland. And she's going to be talking to us about the perceived credibility of digital testimonies, which I think is absolutely fascinating in this context. So I will hand over to Catherine. Thank you.
Hey everyone, how are you doing? So today's my talk is going to be a little bit more practical based. There was kind of such information, so I thought I'd just give a very general broad overview of whether communication is different to online to offline. So how real-time information is impacted and whether it's practical to run online hearings. So don't forget that digital justice is not just criminally focused. You have all sorts of courts and you have all sorts of different hearings, and a judge could hear hundreds of cases a day. So it's not as straightforward as some people might like. So online hearings, it might be repeating some things, could help alleviate the time and resources that are already being put on courts, scheduling conflicts, financial burden on courts and attendees, the backlog, and also practical reasons for travel issues. Some people, as you said, have to travel across the country because Ireland really only does things from one county. So the new argument that's kind of coming up now is whether expert and witness testimonies may be permitted to give evidence via video conferencing now. So we call it digital or computer mediated communication, or how you chat online. So there are different aspects that we kind of think about over in psychology room. So you have online disinhibition. So basically you behave differently online because of anonymity and the lack of a sense of presence. So this can be physically and psychologically, which leads into the media richness theory, which indicates you'd be less likely to lie in face-to-face or in more media-rich environments. I'm using air quotes, nobody can see my hands, which is referenced later. So it's easier to cancel a date over WhatsApp than it is to call. Nobody wants to call anymore. Truth bias, this is my favorite thing. So we are actually predisposed to believe someone is telling the truth. We're not all cynical. The reason is it would take too long to have a conversation. So you have to rely on other things like context of what they're saying, the logic. You're more likely to trust someone if you think you know them. Emphasis on think. And also if you think they're good looking. And this is also the impact of the truth bias is in, so sorry, we have a visitor. Impacted in text and voice real-time communication online. And then you have social awareness. So how well can you understand something from someone else's point of view? Could also impact how you perceive if someone is lying. So communication medium. So what medium do you talk on online? So this is very interesting new development of parasocial communication, where your communication somewhat is mediated by something else, either an interviewer or in this case a barrister or a judge online. And also, this now mediates gives a new medium to watching cases now possibly going online, because public access to cases is quite important in our constitution, which will be mentioned later again. And then, of course, you have aspects of presentation management and testimonies. So to appear friendly and trustworthy and outgoing, to see hand gestures, which I use a lot, but you can't see any of them. Shifting in my seat, maybe appearing distracted by cats walking across the table. But online, maybe you're less nervous due to the lack of immediate social pressure. So, I don't have anyone staring blankly at my face. I'm assuming you're just all paying very good attention to me right now. So, authenticity in testimonies, you can already see the layers are building up here. So video testimonies are already used to read a testimony instead of a lawyer just reading a transcript. Non-verbal behavior is kind of lacking in videos, which can result in an extra cognitive load to try to understand the meaning of what the speaker is saying without the gestures and being able to see their demeanor. Are they sitting forward, backwards, looking around? What are they looking at? Also, the perception of professionalism in expert testimony could be degraded just by bad camera angles, lighting, sound quality, sound and video synchronicity. And then I mentioned earlier presence. So the psychological distance from the proceedings online. So perhaps it could even be considered a form of entertainment rather than a serial legal event. These are suggestions made. I forgot to mention that a lot of this are suggestions made. Nobody really knows the answers to these yet. So, however, online communication is pretty commonplace by now. So is it really that outlandish to have communication online in trials? And exploratory research suggests maybe that decision-making isn't that different online and offline between judges and juries. So that could be interesting. So I kind of got interested as why would someone tell the truth? My background is in deception detection online. And now we're all terrible at telling if someone is lying to us anyway. So it's still 50-50 unless you're trained or have more experience, like teachers or barristers or judges. But so your credibility is quite important in a hearing as a testimony, as a witness. So your testimony has to remain logical and consistent, even more so in online context because people can't perceive your demeanor as easily. And if you're caught out in a lie, so with the lack of physical presence, someone might be tempted to find it easier to lie, but if you're caught out in that lie, obviously the consequences are very significant. So online videos may give less cues to deception, and therefore it is even more important about what a person says and how they say it. But again, possibly online hearings could reduce stress on the witness and assist with intimidation of witnesses to tell the truth. So positive. So are you paying attention? Distractions happen. If you're in a room, other things are going on, someone's cooking in the corner. If you share a house, which most of us do, or you share a kitchen with 2 other cats, things are going to happen around you. So paying attention to videos for long amounts of time does make us tired. And then with online testimonies, you have to give even more focus to what the person is saying. So it relies on the performance of the witness. Again, extra cognitive load. So I mentioned this earlier, and I won't go into too much detail, but basically public access to hearings is in our constitution. It's necessary because the people in the hearing are representing the public. So you have to different levels, and I wonder now if, I don't know if you can see me highlighting something there, the second of the 3 levels, closed to all except journalists. Will that mean online bloggers now? I'm just really interested with that concept. But again, everything is limited to your digital literacy and access, to the increased involvement of non-legal personnel now in online hearings. Also consider people with disabilities who might have difficulty hearing and seeing and perceiving nonverbal cues through online media. You may have reduced communication with counsel, which is a basic, right within a hearing. Very funnily, I love this one, the screen size. If there's a smaller screen, it apparently reduces the authenticity of the speaker. But practically, you need to be able to see evidence that is being presented to the court as well. So you need to have a good access to screen sizes and Wi-Fi. So the other issue, which also was mentioned, is privacy. So I wondered, can you even guarantee privacy offline? Because Ireland is very small. And I could tell you a few different cases where I live where it was supposed to be in court and private, but everyone knew. So that was just something that I questioned there. But I understand the basic concept of, can you guarantee privacy if it's online? So who has access to the videos and links? Say, for example, if it's a closed court case. You're not allowed to record hearings, but if it's online, it could be a bit more difficult to control something like that. There are limited circumstances already allowed for videos. They have already been used since 1992, was mentioned in our statute book, I believe, in 1985 in the US. So then you kind of decide what do you do with all these videos and links, and then thinking about the media. So media has a very important part in helping the public understand legal proceedings and conveying the important parts. So how would the real-time reporting of cases from the original source impact with video clips? What would that mean for witnesses, the perception of the cases being heard? There was the suggestion that it could improve reporting as well, since it's directly from a source. But yeah, there are all these questions that are now coming up that we have to start thinking about. So now you might even have new jobs of certified legal video specialists. You'll have to have new guidelines. You'll have to have specifications for how to take a video. So if I'm sitting close to you, speaking very softly, we feel very intimate. But if I'm lying back, leaning back in my chair, do I look as involved? Do I look more or less professional? Maybe you can tell me that later. So also things about like, what do you do with videos? Are you allowed to have copies, or where do the copies go? How are they stored? So there are these like practical things which aren't necessarily directly to do with the person giving a testimony, but it relates to the testimony they are giving. So again, the benefits, the courts provide a service. It does not necessarily is not necessarily a specific place and time. So holding service online kind of reiterates this fact, or this principle, I guess. So remember, a picture is not always worth 1,000 words. When we go back to the normal, maybe online hearings could still have their place. But if you can do it in a phone call, don't set up a meeting. If you can do it in email, don't do it in a phone call. Just remind yourself, what is the purpose of using a video, either in evidence or using video communication in a hearing? So you could have new classifications such as audio, video, and paper hearings, but there are significant costs to creating video hearings as well, which need to be remembered. So, but again, it kind of increases communication and transparency, and it could allow people to view evidence simultaneously as well. So I think I'm almost finished. So there's a lot to consider here. When Annalika asked me about this, there was a lot of frantic thinking because there's so much. But it was really interesting. And again, so you have to think about how you're going to manage all these things in an online hearing. Wi-Fi, security, psychological distance, possibly perceived entertainment of a serious legal hearing, various involvement of non-legal personnel, and whether digital resources are available just for online trials, which I don't believe it is in Ireland at the moment, or at least not extensively. So I guess in closing, change is needed. We already have significant issues with our current system and how they are held, and issues for witness to arrive and juries to be selected. But right now, from what I can see, online trials or remote trials are seen as a temporary measure. And of course, it's very difficult to apply to all court cases because there are so many different courts and so many different types of hearings. We do need innovation and change, but it should not happen without planning and further understanding of digital testimonies and the impact it has on witnesses and hearings. So I think I got through everything there, and I welcome any questions and thoughts and debates. Feel free to include us on any Twitter conversations.
Okay, great. Could you stop sharing there? Brilliant. That was fascinating, and I think it's really great to hear I know it was quite quick, but the psychological factors that come into play in the various stages of decision making and how we respond to people. And it definitely was much more intimate when you got up close to the camera. I think I'm going to start with a question. So I might ask, if you're in the audience and if you have a question, you might put it into the chat box, and I'll try and filter them through. But just to kick things off, there's an opportunity to say here, like Mark mentioned that, you know, some of these things you think about, but it's never actually really an issue, and there's something we might have to think about these things. There is a way to look at COVID and say, this could be an opportunity to try out some of the other things, because there are very real issues if everything gets too slowed down, as has been pointed out, both for defendants, but also victims and their families and so on, you know, and justice delayed is justice denied. And that's a very real concern right now. So I suppose a general question to the panel would be, at what point do we stop thinking and just jump in? I mean, I know somewhere in the north of England, they're using cinemas to project the trials for the jury, and the jury are sitting in cinema screens. And I suppose in relation to each of your presentations, is there a tipping point where we say, yes, we'll try it, but we'll do it in a very regulated way, and use this as a test point? Would any of our panelists like to comment on that?
This is one of these online things you want to let other people in, but there's no sort of obvious online way of doing that, or knowing if anyone else wants to say anything. Yeah, I think it's a very good question. I think in terms of whether we would make some radical legal change to jury trials, I suppose I think that Irish legal culture is extremely conservative, and I don't think that's a controversial statement. So I think we would basically need a nightmare scenario where COVID goes on for a decade and there's a massive backlog of jury trials caused by, you know, just the reduction in capacity, and if there's a resource issue, that it's not met by, you know, renting more kind of hotels and stuff to provide space to have physical jury trials. So I don't know. I mean, I suppose maybe that's not answering your question. Maybe I'm trying to predict what might happen. I suspect just inertia, but what should happen maybe was more your question.
Well, can I ask you specifically, Mark, because it does strike me that the DVP is permitted to certify in any case that the ordinary courts are ineffective to secure the effective administration of justice. And that could be they're physically unable to secure. You know, it's not limited in that way. Is there an argument for saying that could be used a bit more?
Yeah, I think, yeah, I talk a bit about that in the blog. There was some suggestion that you could say the ordinary courts are inadequate. Personally, I think it's stretching the meaning of inadequacy, but I think there is an argument there. I mean, I think you could say, no, the courts are perfectly, it depends on how you interpret inadequate, I guess. I mean, I think I would favour the interpretation that the courts remain adequate. It's just a lot more resource intensive and more awkward to have a jury trial. And I suppose I think that just from a political point of view, I think it would end up being extremely controversial as a strategy. I don't know. I suspect the likes of you and me would be into every radio station in the land that would listen to us, you know, arguing against it. Yeah, I mean,
it's a really funny point, isn't it, in terms of, because that is an emergency measure brought in for exceptional circumstances, now not being used in an emergency situation.
Yeah, that's very true. That often we're critiquing and writing about the normalization of emergency measures and the application of what should have been emergency measures to non-emergency context. But you're dead right. Yeah, that here you could say, you know, you can say we have an emergency, and there's arguably an emergency mechanism there that is not being resorted to. Yeah, that's very interesting.
Ciara, there's a question comes through on the chat there around property law and drone surveillance and whether the guards need a warrant to survey a person's premises. Can you jump in on that?
Yeah, so I mean, that's a big question that comes up all the time, you know, across numerous jurisdictions, and regular protocol would apply in that case. So property law would stand, they would need a warrant. I guess kind of what I highlighted there in the talk is that at a time like this, when there are more resources going into kind of technologies, into kind of policing and that sort of thing, could that be, going back to your last question, Vicky, I guess, a tipping point to cause all of us to accept the adoption of these technologies? So like, for example, you know, even though the guards would still have to go through their typical protocols, like it wouldn't be like a lawless drone kind of operation state. Is that what we want? I mean, do we want the guards going around flying drones about the place all the time? So I think it asks maybe more existential questions, but legally there is protocol that would still apply if they were operating them.
But of course, they only need a search warrant for private property.
Right.
They can conduct surveillance in public.
Yes, of course.
Without any authorization.
Yeah, exactly.
So you could be using drones around public spaces.
Yeah, and so I mean, with, you know, a lot of the county councils, when they're operating drones, they would be conducting data privacy impact assessments ahead of time. And they would do things like have signage up to let people know that they might be under surveillance in the public spaces. But I think that point kind of goes back to, you know, to my more existential question, like, is this something that we would want? So are we okay with these technologies flying around in public space? I mean, in some places with many people, there is kind of an expectation of privacy in public space. Like often if you're at home with everyone in your house and you want a private phone call, you might go for a walk. So how does that change when we start to see kind of this mass public surveillance happen?
Okay, thank you. Catherine, there's a couple of kind of, I'm going to call them psychological questions coming in through the chat there. And one which I suppose overlays with Mark's work as well, which is about whether juries may rush their deliberations because they feel uncomfortable, or they might want to avoid jury duty. I've seen a lot of lawyers commenting, you know, some are giving us running tracks on how many people are in the courtrooms at the moment. And, you know, there's that issue of, you know, do we put people off wanting to engage with that jury process? Is that a psychological question, Catherine, or am I stretching it?
I have to say I don't know about how much people want to do jury duty. I know I got one once, but I wasn't able to do it, so I missed out on a great opportunity, I'm sure.
So whether testimony is heard in court or online, will the reality of personal bias for those receiving the information remain despite the physical difference?
Well, if you're already kind of up to here with the amount of information you're trying to take in, you do rely on biases as a shortcut. But maybe this person is talking about maybe racism. I don't know enough about jury selection. Maybe Mark could talk about jury selection.
Well,
how do you think that might be impacted online?
Yeah, I mean, it's in terms of jury selection, it's pretty unscientific in Ireland. You know, it's not the same at all as the American system, you know, of where they're questioned. You know, it's very much based on their appearance and quite random. So you don't really, you know, I don't know if that's any help to you.
I think the question's getting at kind of, Catherine, when you talked about personal bias, like that we might like somebody more because they're good looking, or, you know, all those different points. Does that hold as true if the testimony is online?
I think with online communication, we definitely take a few more shortcuts trying to talk because we don't know as much about the person. So we might, in different contexts, in dating websites, we definitely have a lot of biases to assume the person is telling the truth, or we accept in certain circumstances that someone is going to tell little lies. So maybe they're not quite 6'2", they could be 5'10". But with online juries, I really couldn't say. I don't think there's enough information that I could find, but I'd be really interested if someone did have that information.
Yeah, and I think this is one of the things about thinking all of this through is that the different potentials that exist here, whether it's, you know, are the juries hearing stuff online in a separate room, or is it that the experts are providing testimony online, which, you know, we do this already for certain levels of evidence that's been given from vulnerable witnesses or so on, that might be done by video link. So there's the different dimensions to this, because this is one of the things that really strikes me with this, is that, you know, with all three of these talks, and there's a lot of other points we could put in, it's so important not to think about these points in isolation, but to think about the whole context. Because if we did all of these things, that's very different in terms of the right to a fair trial to just doing one of these things, right? Like if you've got like the drone surveillance being permitted, and now you're not having juries and experts are giving their testimony, you know, electronically all at the same time, that's a very different thing. And so I think when people are looking at this and thinking about what's going on, we have to think about the totality of the system and all that we're doing there. Like I'm really struck by the, you know, the fact that the guards have introduced spittles on a temporary basis, but they're doing a review of that, and that's another thing that's happening. Mark, you wanted to come in there?
Yeah, just something you kind of prompted me to think of there, Vicky, is that you could as well, in this strange situation where we don't really know how things like an online jury trial or a remote jury trial would play out, you could have scenarios as well where you could have a proposal that on its face is protecting or preserving or continuing something that we regard as important, like jury trial, but because of the way it's done, it has drawbacks that we're unable to quantify, like, you know, well, we're continuing with jury trials now, but are the jurors actually so afraid of getting COVID, or are some of them so anxious that that's affecting their ability to deliberate? Equally, if you said, well, say in a year's time, all of this is still going on and the government is just fed up paying for leisure centres and theatres and ballrooms in Tullamore and wherever to, you know, have the juries impanelled and so on, and they just say, look, we're going to keep jury trial, but we're going to go online, you know, then you're preserving jury trial, but you're into the unknown in terms of everyone's separately at home, they're not together, you know, you're preserving jury trial, but moving quite far away from what we consider to be really intrinsic to that mode of trial.
And I think that's where a lot of Catherine's points about the psychology of it come in. I mean, I am, particularly if it's remote juries, I get into this whole, like, people are watching far too many reality TV shows, and it does have, but Catherine mentioned it, that entertainment value. And, you know, are you sitting there munching your snacks and deciding whether or not somebody has committed this really serious crime? And, you know, there's a degree of gravitas that should surely come to the role. And maybe on that kind of extremity point about, like, what we're valuing and what we try and retain. Ciara, there's a question there as well from somebody who's quite pro-tech, but doesn't trust the current government with the drone network, given they failed basic ethics on lots of spaces in tech-related areas. So do we allow the government or even our police to use drones, or do we just ban them from public use? How would you approach that question?
Yeah, I mean, it's a good question. And I think, you know, when I was answering the last one, I said that to you, Vicky, like it is more of kind of an existential question, like what type of, you can see my training coming out, what type of society do we want to live in? And what kind of technology are we willing to accept in our kind of public spaces and private space? So, you know, there is a push when there's a new technology for it to be offered as a solution for every problem. So the guards, the police in numerous jurisdictions see possibilities and use for drone technologies. So, you know, I guess it's a question of, you know, what are the limits of that use? I think it would probably be inevitable that An Garda Síochána will take up drones. I mean, it is a trend internationally that police forces are picking up drones. But then what are the limits of their use? So we know people will have fierce reactions if drones started flying about and giving out speeding tickets and, you know, started following suspects down the street. We know people wouldn't like that. But if they use it for things like accident scene surveying or crime scene reconstruction, that can be very useful. So yeah, I mean, it might be more of a question on like what the limits of that use are as opposed to a blanket ban. Because these all go through kind of business case assessments now as well. So it's a formality really if they want it, I think.
The obvious one that strikes me is combine it with a thermal imaging and know how many people are in a house right now.
Yeah.
Which is potentially very invasive, but does it have it kind of feels a bit apparent to me, but then quite genuinely, is there a very real public health risk that could be mediated in some way through using technology?
Yeah, definitely. And LiDAR, that's where you can see thermal imagery inside a house. That has been used by military drones for years. So the tech is out there.
We've all seen that in movies, haven't we?
Yeah.
And then the other side, of course, of the technology, which is being considered, is the use of body-worn cameras by the police, which is also equally interesting and can be really effective in some spaces. We know that if there's body-worn cameras at the site of a domestic violence call-out, there's a much greater chance of a prosecution because you get that immediate evidence of the disarray of the house and the temper and the people's body language and everything is all captured. But it can be really problematic in other areas as well. Somebody questioning there, should you therefore limit drones to when there are suspicious circumstances? So would that suggest that there has to be a trigger? So you can use the drone where there is a reasonable suspicion of?
Yeah, I mean, I guess they're talking about your example in particular about kind of the thermal imaging. And I think, so if we're talking about drones just to fly around and kind of take a bird's eye view, I already have a visceral reaction to that personally. Now, obviously I'm biased, and I think, drones are kind of like the mosquitoes of the technology world. Like, they buzz around and they're a bit disconcerting. Even if they don't bite you, you're not really a big fan, But with all of the different technologies, then it's like it's layered. So it might just be a drone, or it might be a drone that can collect thermal imagery. If you knew a drone could see inside your house with thermal, I just think it's a step too far, even if people have more than 6 individuals within their household.
Yeah, it's challenging, and it is a very real prospect of things being introduced, like I suggested, the split notes in the Garda stations, at least a proper review be conducted in relation to that. But we need to be very careful, and it's interesting to see what has been introduced by the Guards and where they haven't as yet. Although I suspect that may be a resourcing issue as much as anything. And on both fronts, we should be pleased to say today's budget includes, I think it's 258 million for both Garda and Court ICT. So that is encouraging, at least. There's a comment that from a former Garda that the jury trial must endure what Mark is right about the only changes that online may bring. But is not technological change always so? And I think that's a really good point. I mean, to what point are we just a bit scared to go there, and when do we take the leap? Mark, do you want to comment?
Yeah, no, I think it's a very good point. Yeah, I mean, and jury trial has always, it's presented sometimes as this immutable thing that never changed, but it has changed all the time. I mean, we haven't even had 50 years of women jurors in Ireland, so it's always changing. It was thought that unanimous verdicts were an essential ingredient of jury trial for hundreds of years, that tied in with beyond reasonable doubt. So, I mean, yeah, it can change. I suppose I would slightly, the points you raised, Vicky, earlier about the potential lack of formality if everyone is in their home, maybe that's then not the answer, but maybe it is about having the jury in a different venue, but together or something like that, using a TV link or something. I don't know, but yeah, I mean, it's a good point. Yeah, maybe we're just afraid of change, but I think I would really err on the side of caution when something so significant is at stake.
Yeah, Catherine?
Yeah, I'm going on with you. Like, maybe for those slightly less, let's say, involved cases. So the traffic fines, the alcohol license, maybe they could be online because they don't seem to be as involved, you know, and then that could clear up resources for other cases. What do you think?
But a lot of those are district court issues anyway, which wouldn't often tend to have a jury. But yeah, if you could do them online. Like the licensing applications, there's a real question there. And that probably does take up a lot of time.
Yeah, and the approach in England with their Nightingale courts seems to be to try and get non-jury stuff, to other venues, so that then jury trials can happen in court buildings. So maybe you could, by analogy, then say, well, if you were able to get some of the more straightforward court business online, maybe it would free up space for jury trials, maybe.
I mean, the courts have always been incredibly so in terms of moving online. I remember when I was a student, Justice Denham giving a talk in UCC about moving to paperless courts, and 20 years on, that has not happened. And, there is a very real point there about the degree to which our legal system is still very, very paper dependent, and how even, the guards and the DPP and the courts, prisons and probations will all use different identifiers for the same individual. So you can't track a case properly across the whole system. And that can really slow things down, often causing significant problems for, accurately knowing what is even happening. When the guards prosecute, do they actively find out what the result of that is? So there's a lot of, and maybe it is one of those moments where we need to step up and take those leaps to use technology, but doing so in a properly risk assessed way, whether that's about privacy, but more general fundamental rights. There's a question about what are the views on the New Zealand system, whereby the accused will be tried by the judge alone unless they elect for a jury trial.
Yeah, I think it's interesting that question of waiver is coming up, because again, I would have just sort of thought, well, that's an academic issue, that'll never appear. But I mean, I suppose you could say, well, the Constitution mandates jury trial in particular situations, and that's a very important safeguard. But I suppose on the other hand, you could say, well, is that very paternalistic? If somebody doesn't want a jury trial, but I don't know, part of me, my response to that would be, well, maybe somebody could be coerced into waiving their right to jury trial, and I don't know, but that is maybe paternalistic.
Of course, the flip is that arguably doing jury trials technologically might enable the inclusion of some people that would otherwise be excluded from juries because of their circumstances.
That's true, yeah. And certainly the fact that jurors don't get paid any expenses was raised with us as a significant issue in the interviews we did with judges, and they felt it was a real disincentive for people to do jury service. So that's true. Okay,
it is 6:30. It's the end of the day. Everyone has stuck through, and there's been really excellent participation in this event. I am going to do a slight plug based on that final conversation for the podcast that I've recently started, Policed in Ireland. And there is actually, if you're a subscriber, there is an interview with Virgil Davis on a special criminal court where we talk about the reasons why our jury is important and so on. So some of you might be interested in that as well. But can I please, you can't all join me in applauding and thanking our three speakers, Ciara, Bracken-Roche, Mark Coen and Catherine Friend. Really interesting presentations, very thought-provoking, and I thought they merged really, really well and really threw up some very important questions about how we manage the right to fair trial during a time of emergency and a pandemic. So you can see on the comments there, people are really grateful. They've really enjoyed the conversation. So thank you so much for speaking to us this evening, and thank you to all of the audience for engaging. There were great questions coming in there, and a very big well done to the Law and Society Review for hosting this event, and I hope there'll be more of them this semester. It's been really good. Thank you.